State.
We've reached the penalty phase. The state, in filing its notice of intent to seek the death penalty, set forth 2 aggravating factors. The capital felony, this murder, was committed for pecuniary gain. And 2, the capital felony, a homicide, was committed in a cold, calculated, and premeditated fashion without any pretense of moral or legal justification. As you heard from the court, before you even begin to consider whether or not a death sentence is appropriate, you must first determine whether or not at least one aggravating factor that has been alleged by the state has been proven beyond a reasonable doubt. During this proceeding, the state will not recall witnesses to the stand. Rather, we will rely both on the testimony and the evidence that was introduced during the trial, during the guilt phase, and which you saw and you heard. After all, it has been a short time since the guilt phase of this trial ended. And the focus of the state's case during the guilt phase was the planning and design, the attempt to hide the nature of the murder, the use of prepaid anonymous phones, the arranging to be out of town, the enlisting of people who lived 1,100 miles away. And you may view all of the evidence that was introduced during trial when you retire to deliberate. Now, as indicated, the state has set forth 2 aggravating factors. So let's talk about the first, pecuniary gain. That is a financial gain. During this trial, the evidence established that $5.8 million was placed in an irrevocable trust that had been made by Teresa Sievers and for which Mark Sievers was the trustee and the primary beneficiary.
Excuse me, Your Honor, I would object. This is just argument instead of opening.
Overruled.
The evidence established, and the evidence to which the state relies, is that $275,000 to $550,000 a year would be the annual income. And in fact, when you look at Defense Exhibit number 10 on page 6 of that trust, which is in evidence and to which the state will be relying, Section 3.2 II made clear that the trustee, and that was Mark Sievers, shall be liberal in making discretionary distribution even to the extent of exhausting the family trust, and the trustee, Mark Sievers, shall consider the needs of my spouse, Mark Sievers, before making a distribution to the benefit of any other beneficiaries, and it is my primary intention to care for my spouse. In addition, upon Teresa Sievers' death, proceeds from the State Farm life insurance and proceeds from the Jackson Life IRA were to be distributed directly to Mark Sievers, and their combined total was about $427,000. The evidence presented and the testimony, and I want to refer to some of that evidence, State's Exhibit 61 and 61A is the State Farm life insurance policy of $300,000 for which Mark Sievers was a direct beneficiary. State's Exhibit 62A and 62B the Prudential life insurance policy of $2.5 million, for which Mark Sievers was the trustee and the primary beneficiary. States Exhibit 63A and B, the Ohio life insurance policies. There were two policies, one for $2.5 million, one for $0.5 million, totaling $3 million, to which Mark Sievers was the trustee and the primary beneficiary. And then States Exhibit 64, the Jackson Life IRA of Teresa Sievers, with a death value of about $127,000, for which Mark Sievers was the direct beneficiary. And then the testimony of Curtis Wainwright, who testified that he was to be paid, Mark Sievers talked about at least $100,000 from the life insurance that would be received. And he told us that Mark Sievers said to him, "There's a lot of life insurance. The kids and I will be well taken care of." But he let him know that he, Curtis Wainwright, and I guess, as we now know, Jimmy Ray Rogers, would have to wait at least 3 months until the life insurance was paid. The second aggravator that the state is relying on is that this was a cold, calculated, and premeditated murder without moral justification or legal justification. And again, the state will not recall witnesses to testify, but will rely on the evidence that was introduced during trial and will rely on the testimony that was heard in trial. The evidence in terms of exhibits, testimony is evidence, the evidence of the testimony, to establish that this murder was done in a calm and cool reflection, was done after calm and cool reflection, that it involved careful planning and a prearranged design to commit the murder, and the murder occurred with a conscious decision to kill. So much of the testimony and exhibits in the guilt phase of this trial speak to the cold, calculated, and premeditated nature of this horrific homicide. This crime was planned over time. You heard the testimony. You saw the exhibits. To highlight just a few of the exhibits and just a small amount of the testimony. The Cellbrite extraction, States Exhibit 25A, as well as what you find in Defense Exhibit 2, demonstrate that on April 29th, 2 months before this murder, Mark Sievers was reaching out to Curtis Wainwright to tell him he needed to discuss a personal matter with him. The matter would turn out to be the murder of his wife. And Mark Sievers would not be dissuaded. And the testimony is that he began at that wedding of Curtis Wainwright to begin the planning, to talk about anonymous phones, to talk about payment with life insurance. Exhibits and testimony. 2 days after returning home on May 5th, Mark Sievers purchased tickets on Delta Airlines, States Exhibit 59, that had Teresa Sievers returning home 2.5, 3 days before Mark Sievers and the children. Planning. The series of text messages that are in evidence and have been highlighted periodically during the guilt phase of this trial. For instance, the message on May 7th from Mark Sievers to Curtis Wainwright. Since neither one of us are likely to carry both with us, whenever you want to use the other, just text me in quotes other, close quotes, and then when I can, I will call. Or the coded quote other, close quote, messages. For instance, the one on May 17th, where it's check other and then hello brother from a quote other close quote mother. Again, State's Exhibit 25, Defense Exhibit 2. The purchase of a prepaid anonymous phone from Walmart on May 7th, 2 days after the purchase of the airline tickets. That's State's Exhibit 67. The multiple calls made on the anonymous phones between Mark Sievers and Curtis Wainwright, which are in a call log found on State's Exhibit 104. The state will rely on your recollection of the testimony of Myra Simmons, as she outlined how the prepaid anonymous burner phones were detected, including the chart she used to assist us in understanding that path that had to be followed, that multi-step path in order to find these phones, and the 21st century software that was necessary in order to actually be able to extract the information from thousands and thousands and thousands of phone numbers. The shredded policy, that life insurance company, the shredded policy found in Mark Sievers' office for a disability policy for Teresa Sievers. State's Exhibit 18, Defense Exhibit 6. And the evidence goes on. The state relies on the extensive evidence. These are just a few examples during the trial that made clear the long planning and that this was a product of calm and cool reflection. It was a careful plan. It was cold and calculated. Mark Sievers suggested making it look like a burglary. Mark Sievers suggested the use of anonymous phones. Mark Sievers sent a check to Curtis Wainwright for $600 to pay for the expenses of traveling from Missouri to Bonita Springs for this murder to occur. Mark Sievers pulled up Google Maps with Curtis Wainwright to look at the medical office practice building. And when Curtis Wainwright asked Mark Sievers, what if somebody was walking out with Teresa Sievers, Mark Sievers' response was, there are to be no witness. They're collateral damage. Cold, calculated. This was a plan that was hatched in Bonita Springs, Florida, incubated in Missouri, prepared between 2 states, and executed on Jarvis Road on June 28, 2015. This morning you will hear from the victim's family, from Teresa Sievers' family. Their testimony is not an aggravating factor and should not be so considered. As His Honor will instruct you, such evidence is to demonstrate the victim's uniqueness as an individual and the resultant loss to the community. Ms. Groves, the mother of Teresa Sievers, will speak to you about how her daughter's death has impacted her, the family, the community. You'll also see a short video of Teresa Sievers. During this phase, after the state has proceeded, the defense will have an opportunity to present mitigation. Then both the state and defense will have an opportunity to speak with you again. And then the court will instruct you on the law. And then it will be time for you to reflect, to deliberate, and to determine your recommendation. Thank you.